Hello everyone, welcome to the channel. It's Tuesday. Today was a long day. A long day. So Keith, Adams, Shard, Weinstein all got to cross Mr. Wright, Antonio Sledge's lawyer, and then Love had direct and redirect. Let's just start at the end of the day with the judge being happy that Sledge's direct and Wright's direct took less time than Woody's direct. Because I think Woody was on the stand on direct for about 17 days in total. But mind you, some of that was, he was off the stand. They redid some of it, but you know, it is what it is, whatever. So she felt like that was an accomplishment. Okay. That was an additional witness that really didn't have to be a witness, but they added, and clearly they can add witnesses as they see fit. We have 99 witnesses left to go, unfortunately, because, you know, unfortunately one did pass away, Rich Homie Quan, rest in love. But they still got 99 more. We can't average this. This is not okay. In addition to that, her whole point of putting Antonio Sledge's lawyer on the stand was because Antonio Sledge thought, legitimately, if I signed okay to all this mess you want me to sign okay to, then when I get in court, if I don't agree with something, you will allow me to speak the truth about it, or what I feel like is the truth about it. At least that's what he thought. Yeah, I'm on the struggle bus trying to put my dadgum seatbelt on. That's what he thought they were okay with. And according to his lawyer's testimony, that's what he thought too. I don't know if anybody caught this, and I will try my hardest to go back and find it. But that lawyer said to Love on redirect, I would really like to go back and look at the emails between the last couple of corrected versions of the plea agreement that you sent me prior to us getting or signing those pleas, or when that came in, just to verify when it came in. And I think what he was insinuating was you might have snuck that language in within a shorter period of time before we had to go to court to sign off on this. Unless, this may sound very biased, and it's intended to. I'll just say that much. But let's not play like, regardless of what they put in that plea agreement, under the watchful eyes of Judge Glanville, they weren't gonna get away with it. Let's just be correct about it right now. If Judge Glanville was still on this case, in this same situation that happened the last couple of days, happened with Glanville, he would be saying, too bad, so sad. Ain't my fault you didn't catch the discrepancy and agreed to it. That's your fault. And Judge Whitaker is not saying that, but she's not saying that either. But what she allowed the attorney to do is at least acknowledge that may have got snuck in on me. And, you know, we were in the last moments of signing the plea agreement. And as you can see, they both was just, you know, masked on, focusing on the judge. And I don't even think Antonio Sledge was even paying attention to her. He was just kind of like, for a lack of a better term, kind of like in a daze. Just like, yes, ma'am, yes, ma'am, yes, ma'am, yes, ma'am. Because he was just so tired of being in jail, and he knew if he said what she wanted him to say, that he would get out. But let's be for real. You put 8 in one of the 5 versions. You kind of jumble 8 in with some other wording in one of the versions. You take 8 out in 2 of the versions. And in the last version, you made sure you snuck 8 back in. You could say it didn't sound intentional, but it might be intentional. I feel like it's intentional. I may be biased and I don't really care. But judging by what Love has done previously, she's sneaky like that. And, I know I have a video on my channel. It's about 2 hours long. It's long. But it actually included 4 months. Love kept saying that Brian still kept trying to say that Adrian Bean went to Grady, he never went to Grady. She kept arguing this before Glanville. I actually found the day, and I think it was like day 42 or something like that, where then she steps up before Judge Glanville and says, Brian still keeps, it wasn't the argument anymore about Adrian Bean going to Grady. It was, Brian still said he was talked to by a detective, and we have no proof of that. And then Judge Glanville says, well, did you ever find out if he went to Grady? And her voice changes. Well, he went to Grady, but it was Grady detention. So Judge Glanville then asks, well, is that at Grady Hospital? Yes, but it's in a different part. None of that is relevant at all. The point was he went to Grady. And the most interesting part about it is Brian still knew he went to Grady because you put in the radio traffic dispatch tapes that had them taking him to Grady Hospital. Okay. And now you sent over some emails to show that you made 5 different versions of the plea agreement in less than 24 hours. 5 different versions in less than 24 hours. Some you remove language, some you put language back. And then you snuck what you really wanted to be in there in the last plea agreement and said, you got to sign this. This you'll get out of jail ticket right here, right now. And if you don't agree to it right here, right now, the plea deal's off the table. You're going to stay in jail. If that ain't the best form of pressure, aka coercion, you're literally dangling someone's freedom in their face. It's like someone who's dying and you have the magic pill to heal them. Yes, they're going to do whatever it takes to get that pill. They're not going to be like, just let me die. It's the same thing. Whether they stayed in jail or not had nothing to do with, just, them banging with people and their lives being at stake from rival gangs. These men had just regular beefs with people in the streets. Just me and you ain't getting along. We humping on the same female. We share the same baby mama and I'm still sleeping with her, but you be talking crazy to her, so I'm tripping with you. I mean, these people have everyday problems, and for Love to act like people don't have everyday problems. And this is what really pisses me off. So it's okay for you to bring a witness in that ain't looked at this case in 10 years until you brought it back before they face within the last couple of days. It's okay for them to not remember anything, but it's not okay for somebody who's charged in this indictment or severed from this indictment or on this indictment to not remember some crap that happened 10, 15 years ago. They can't not remember. They have to remember every instance of every incident in their life. But your witness can't forget. That's okay. That's okay. It's okay for them to forget talking to police officers or what was said during the conversation because, it was years ago. It could have been 2015. It could have been 2016. It could have been 2017. I don't really remember. That is okay. But it's not okay for Antonio Sledge not to remember. It's not okay for his attorney not to remember. It's not okay for Tick not to remember. It's not okay for DK not to remember. It's not okay for the dude that was in chain gang prison that was with the dude that got his head shot. It ain't okay for none of them to remember because they there in the capacity of defendants that you need there. They're not really witnesses. They're really defendants that you're giving a break if they testify the way you want them to. Why is it today was so petty? Every time Love brought something up for the last 2 days, for sure, Monday and Tuesday. Every time, and she'll probably continue to do it until it happens the way she wanted to. Every time, it's I need you to admonish them. I need you to tell them in front of the jury they shouldn't be doing that because she got admonished. And I think Keith Adams said it back best. We going tit for tat now because she got admonished, so everybody else got to get admonished too to make her feel better. If this ain't the pettiest auntie I done ever met, and I do mean pettiest auntie I ever met, like, I have no words. You did not need to spend a day and a half on the damn stand with an attorney to talk over a mistake that you made. You could have gotten that done in less than 2 hours. Let's be for real. Keith Adams, probably in total, maybe an hour. Weinstein, minutes. Under 10 minutes. So far, every time he crossed. Under 10 minutes. Under 30 minutes for sure. Sharp sometimes. Sharp and still drag things on a little bit. But usually for Sharp got a whole situation in his head and he needs you to see the movie. This man then wrote a whole script and he need to walk you through every scene of this movie. And that's usually what his is. And I swear to you, when he done, you see the picture. Still, sometimes because he's so long-winded, he could talk over himself a lot and you get lost in the sauce. He's very similar to Love. And that's why I think the reason why they bang so much is because it's the ego. They both have really big egos. And right now, I feel like, and this is my personal opinion, you ain't got to agree, you ain't got to like it. Brian still is on trial with Thug. He is. The way that they treat him is almost like he is a defendant too. And they started treating him like that with Glanville from the very beginning. They did not want him on this case. And there was a reason why they didn't want him on this case. He is good and he has resources. But the way they treat him is like he's on trial too. So part of it is he spent years creating his reputation, building his brand to in the state of Georgia and around the world as a reputable defense attorney. And with this case, the county of Fulton is trying to make him out to be a criminal. You literally held him in contempt. And I don't actually know if he went to Rice Street or you just claimed to have sent him to Rice Street. But that man when I say that man got a chip on his shoulder, he do. And as far as he's concerned, he gonna burn this whole damn case up. Y'all started with his client, and that made him mad. But when y'all brought it to him, y'all pissed him off. And that man is out, for lack of a better term, out for blood. And he gonna take it in that courtroom. Because that's what he does, and that's what he knows best. He knows the law. And he's going to use the law to vindicate himself and his client. So don't blame him for what he's doing. Blame the state for opening that can of worms. Because it didn't have to be done. Regardless of how it was told, how Woody was handled was wrong. On all accounts. By his own admission, he's a liar. But y'all was okay with him lying as long as he told the lies y'all wanted him to tell. And when he said, I ain't going to tell the lies y'all want me to tell, I'm going to tell my truth. And I'm going to let everybody know the lies that I was telling was lies. That pissed everybody off. And the Chief Justice of the Superior Court of Fulton County was not willing to accept that he was wrong. And in reality, Glanville, Love, and Brian Steele all had huge egos. And none of them would let stuff go. None of them. Glanville had to be forced off the case. Love gonna keep it up until she forced herself off this case or she forced this case into a mistrial. Because she's sneaky. And she feel like, well, if I just don't tell them, then it don't exist. Well, they have other ways of finding out if it really does exist. Like, she doesn't have to give them the emails that she sent to other attorneys. In all reality, they can just go ask the other attorneys and ask them if they're willing to submit that as evidence. If they would be okay with that. And if they agree, because their clients already have their plea deals, they got what they need. And at the very least, they can compare it to what she gave them. And you know what? It would be funny if they already did it. But love is sneaky. How much you want to bet that she ain't going to be ready with this by tomorrow? She going to be still working on it. It's going to still not be completed. Mark my words. Mark my words. Today was a whole lot of pointlessness. But this was all about love trying to prove her point. And, you know, again, she a petty auntie. So whatever she can do to prove her point, because y'all not gonna be talking about her. That's exactly what she gonna do. Yeah. I don't know. That woman burned my butt. She is so damn petty. It hurts. But it is what it is. I enjoyed the show. I enjoyed the chat. Thank you to my members. I got 56 now. Like, share, subscribe. My hubby started a live today. I seen that. That was so cute. I was like, you can help your girl out here. I'm trying to get me some more subscribers. And he was trying, but he just had his big old face in the camera the whole time. So that was it. But anyways, like, share, subscribe. Thank you guys for tuning in. Thank you for all the love. Again, thank you for the comments. Hopefully pretty soon I'll be able to start lives. But, you know, this is just my rant on the way home or on the way to work. So it is what it is. But on off days, maybe I can try. But unfortunately, my schedule sometimes coincides with their schedule. So I really don't get to be off when they're in. I'm unfortunately in when they're in at work when they're in session, and you know, whatever. But we'll work it out. The more you subscribers, the more stuff I'll be able to do, and hopefully soon I get off my phone and get like maybe a tablet or something just for doing my videos, so I can stop using up all my phone space. But whatever. Thank you again, you guys. Thank you so much for tuning in. I really do appreciate you guys. Thank you for listening to my mess. And if you agree, don't agree, I appreciate all opinions. This is an open channel. Please voice your opinion. Talk about how you feel. Interact with the other people that are commenting. You know, this is for us. It's a rant space. It doesn't matter what it's about. Just feel free. I want you guys to feel like this, like you're free to just voice your opinion, because that's why I started the channel. It's just to voice my opinion, my theory, my thoughts, my views. That's it. And you guys are welcome to do the same. But thank you. Till next time, guys. Peace.
Quite honestly, the rest of it is essentially just describing the video. It's correct. And then ultimately, at the very end, where it was added, had begun a relationship with defendant's ex-paramour. That was correct. So the only issue was an inference that it was in the furtherance or in support and express loyalty to YSL. That was the only part that we took issue with. So that's where, when I say sometimes there's something where we agree, but also part of it disagree, that was the part of disagreement.
And to not split hairs, but did you at any point say in your email or anywhere else that that part is factually incorrect?
No, but also understand, my email came the day before. As we started getting into these later versions, I was here in court. I wasn't sending emails. At that point, we were communicating verbally back and forth because we were sort of both here. So, but the point being is, that was something that my recollection is, hey, we changed it to the extent we're going to change it, and that ultimately you weren't going to change it further, or, eliminate that. So my client, as he, I think, testified to, would say, look, some parts I may not have liked, and guess what? When asked, I'll explain it. But ultimately, I don't want to not do a plea. I want to get the plea done so I can move forward. And that's that point of compromise.
Thank you for explaining that. All right. Your Honor, I would also at this time ask the court to conditionally admit 452, 460, and 453, not for publication at this time, but subject to additional restrictions as the court sees fit, and we can discuss off
All right,
outside
we're
the
not
presence
gonna
of the jury.
conditionally admit them. If we want to talk about them more, we can talk about them more.
Yes, Your Honor, thank you. While you were on cross-examination, you testified that some of the factual allegations that were contained in the final plea agreement were not ones that you had agreed to. But on direct, am I correct that you said number 3 you asked to be changed and it was changed, but not exactly like you wanted? And then number 8 was one that you said today that you missed back at some point when you were reviewing the document.
That is correct.
Okay.
I have said today that number 8 was missed.
Okay.
And a review of it versus our earlier comments to you, they can't be reconciled. I mean, in other words, it's clear that that was not something that we would have anticipated. In other words, it was something we objected to and wanted removed. Ultimately, it reappeared in that final version. We did sign it. Again, I'm not taking issue. We missed it. And unfortunately, had I seen it the day of, I would have paused, stopped everything and said, this is a hard stop. We got to figure this out.
We'll come back to that in just a moment, okay? Other than number 3 and number 8, do I remember correctly that everything else your client through you acknowledged was
Objection, Your Honor.
accurate?
Asked and answered.
Sustained.
When you spoke of some of the factual allegations, were number 3 and number 8 the only two
Asked
you
and
were
answered.
Sustained.
outside of what's contained in the final 1AS? Is there any other thing that you asked the state to change that we
Your
did
Honor.
not?
Asked and answered.
I think that was also asked and answered.
I did. Okay,
Objection.
we'll move forward. Now, as I said, when you mentioned number 8 being something that you had not seen before, are you able to tell the jury the first time that you can now recall paying attention to number 8?
Number 8, when you were questioning my client and number 8 came to light, one of the first things I started to do was go back to read to figure out where that came from. And of course, my reasoning without going into the content was that was from the very early things that we said, hey, this is not accurate. And then I'm thinking, where'd that come from? But I went back, I realized it was there. How we missed it, how I missed it, I don't know. But apparently I did.
If I show you number 8 on 455 Yankee, an email dated December 28th, 2022 at 1:54 p.m., are you able to recall whether this was a document that you reviewed while you were actually in court?
I believe that was one that I did review while in court. I think you said 155?
Yes, sir.
Yes,
455.
455.
I don't know.
455 Yankee. Now, without reading out loud number 8,
Okay.
read to yourself number 8. And after you've done so, would you please tell the jury whether number 8 under factual acknowledgments under 455 Yankee is something that you asked the state to change?
If we,
With just
okay.
because I can't have you read it.
No, I'm not going to read it.
Okay.
But what I was going to say is, having read it, ultimately, only the very final part, the last sentence, really the and then everything after that is the only thing we would have asked to be removed from this paragraph. So essentially, you could say almost the last 2 sentences.
And so 455 number 8.
Yes.
I'm going to object under 403, misleading the jury. Mr. Wright has been referring to number 8 on the final agreement. Now we're talking now. Ms. Love is trying to talk about number 8 on a prior version, which is not the same.
I hear you. I think she was maybe about to ask some questions to clarify that.
I was, Your Honor. And just to be clear, because there was this cross-examination about what was agreed to, what the state refused to move.
Right.
So this, we believe, is a proper line of inquiry, and we'll try and keep it as concise as we can. So may I continue?
You may.
So, Mr. Wright, when you speak of the change you requested on number 8 of 455 Yankee, does number 8 on 456 Yankee, is that the difference, and is that the line that you're referring to that appeared in the final version?
Well, they are 2 completely different statements.
Right. And does 456 Yankee contain the line that is now contained in the final version?
No, what I can see is that in 455 Yankee, where item 8 in that document was the one we had been talking about, and we took issue with the last couple sentences of it. When it becomes 456 Yankee, that is moved to being now number 9. The lines in question were in fact removed, but a new number 8 is inserted, and the new number 8 is what I said we missed. We didn't see that because it had not been part of the prior version. So, but you can sort of see by comparing the two that what happened was it got kicked down to 9. A new number 8 was put in, but number 9 does in fact remove the line at issue in the old number 8. If that wasn't confusing. Okay.
And what I was asking you is that in 456, that line in 456 Yankee, is that number 8 the line that appeared in the final version?
It did. Okay. And again, I'm not sure how we missed it. I think because I'm thinking, and again, I can't speak for my client. I can only speak for me, that we were still going off the last thing we had seen. Honestly, I know this final version got emailed to me. I'd be interested to know, just to be sure, what time the plea happened versus this email, because that would make sense as to if I didn't see this last version email before we ended up taking the plea. And again, I'm not saying it did happen. I'm just saying I'm trying in my mind to figure out how we missed that. How did that happen?
And as you